Your Honors, may it please the Court, I am grateful for the opportunity to address you today. I bring a perspective drawn from the original intent of the drafting of these documents more than 2 decades ago. Hereafter, when I use the term proprio motu prosecutor, I mean the Article 15 proprio motu prosecutor. When I use the term prosecutor, I mean the prosecutor who acts in response to a referred situation. Pretrial Chamber 2 misinterprets Articles 15 and 53 of the statute and Rule 48 of the Rules of Procedure and Evidence. Its cumulative reading of these provisions in its decision leads Pretrial Chamber 2 to diverge from original intent and distorts how it should be addressing interests of justice. The writings of my French negotiating colleague Gilbert Beatty in this respect, and the amicus brief submitted by Professor Dr. Kai Ambos and Dr. Alexander Heinz of Germany are recent sources of interpretation that I embrace and strongly recommend be examined. As a drafter, I also found Mr. Tim Maloney's presentation on behalf of the victims yesterday particularly compelling. First, I will answer question CA. There is a clear distinction in the Rome Statute between, first, the proprio motu prosecutor's obligation under Rule 48 to use Article 53(1) criteria in determining whether there is a reasonable basis to request authorization for an investigation, and second, the pretrial chamber's reliance on the same Article 53(1) criteria for review, if necessary, of the prosecutor's initiation of an investigation in a situation that has been referred by a state party or the UN Security Council. Rule 48 is an explicit direction to the proprio motu prosecutor, and only to the proprio motu prosecutor, to incorporate the factors in Article 53(1), paragraphs A, B, and C, in her determination as to whether there is a reasonable basis to proceed with an investigation under Article 15(3). Those factors are vital criteria that should be met, with the final one, paragraph C, being a calculation, if invoked at all by the proprio motu prosecutor, that the U.S. delegation envisioned typically concerned, for example, the operation of a truth commission, some kind of conditional amnesty deal to achieve peace, a justice alternative under complementarity, and or other options for the victims to seek justice. If the proprio motu prosecutor determined that the Article 53(1)(c) criterion was met, namely that it would not serve the interests of justice to proceed toward an investigation, then the pretrial chamber would not be seized with the issue, because the proprio motu prosecutor, technically at least, would not plead under Article 15(3). That was our intent, to provide guidance to the proprio motu prosecutor in Rule 48 about what she needed to do for an Article 15 exercise. We did not get to that issue in Rome. We addressed it in the rules a short time thereafter, as Judge Prost sought clarification on yesterday. This is the interests of justice determination set forth in the final sentence of Article 53(1) only applies for referred situations by a state party or the UN Security Council. This is because there would not be an Article 15 application to initiate an investigation if the proprio motu prosecutor determined that the interests of justice compelled her not to investigate. The application would not be made because the Article 53(1)(c) determination by the proprio motu prosecutor would have negated the purpose of any request to the pretrial chamber. Of course, the proprio motu prosecutor could volunteer such a negative determination to the pretrial chamber to gratuitously explain why a preliminary examination should not mature to an investigation. But there is no statutory requirement to do so if the proprio motu prosecutor is not seeking authorization to initiate an investigation. Your Honors, the final sentence in Article 53(1) was intended to apply solely to referral situations where the prosecutor would need to inform the pretrial chamber of her negative determination so that the pretrial chamber could review the prosecutor's rationale to cease investigating a referred situation. We knew that would be a controversial moment because the prosecutor would be trying to terminate investigation of a referred situation. So the pretrial chamber would need to step in to evaluate the prosecutor's decision and possibly reverse it. In comparison, the logical procedure for the proprio motu prosecutor is to satisfy the positive criteria of Article 53(1)(a) and (b) as the basis for seeking authorization to investigate a situation. The pretrial chamber has no statutory basis for inquiring beyond the merits of those two criteria if the proprio motu prosecutor is not volunteering an Article 53(1)(c) negative determination. But as Ms. Brady acknowledged yesterday, the pretrial chamber can ask the proprio motu prosecutor to explain how she addressed paragraph C in her preliminary examination. The U.S. delegation was focused on ensuring that the proprio motu prosecutor's powers would be strictly conditioned on obtaining pretrial chamber approval for an investigation of a situation, the legitimacy of which must be argued on jurisdiction and admissibility grounds. Negotiators did not endorse the pretrial chamber standing in the shoes of either the proprio motu prosecutor or the prosecutor following a referral, and then itself initiating a determination that investigating the situation at hand would not be in the interest of justice. Any such power under the Rome Statute would invite the pretrial chamber to unilaterally delve into possibly politically influenced rationales for shutting down the investigation of atrocity crimes. If we had intended such a role for the pretrial chamber, it would have been drafted into the Rome Statute. The original intent of the drafters was that there be no statutory requirement that the proprio motu prosecutor affirmatively stipulate reasons why an investigation would serve the interests of justice. There was discussion based on the original British draft on this point, but the idea was rejected. We recognized that any such requirement would impose an almost intolerable burden fraught with politicized rationales on the proprio motu prosecutor and the pretrial chamber to conjure up any manner of moral and politically acceptable reasonings regarding a prospective investigation. Now I will answer question B. Your Honors, the founding drafters did not define the term interests of justice because it can mean so many different things to so many different prosecutors and judges, not to mention governments. We did not want to open that can of worms, and in doing so, possibly lose the point entirely during the negotiations. If pretrial chamber 2's decision is permitted to stand, it would be like forcing a political leader to explain why she pursues political objectives, or asking a scientist why he seeks the objective truth in his research. That is all self-evident. But grafting it now onto the Rome Statute by adopting pretrial chamber 2's decision in this situation is dangerous. Drafters framed this requirement strictly in the negative because of the obvious purpose of the International Criminal Court, as with credible national courts, to operate within the framework of the interests of justice. Stipulating a requirement that the proprio motu prosecutor and the judges must demonstrate that they serve the interests of justice, or else the request to investigate will fail, would be oddly self-evident drafting, but also invite speculative and politically influenced decisions. Witness paragraph 91 of the impugned decision. Who in the world dreamed up such criteria, neatly framed to obliterate the Afghanistan situation? My goodness, if in the 1990s, when building 5 war crimes tribunals, one had followed the factors in paragraph 91, there would have been no cases and no jurisprudence developed because the arc of international criminal justice is very long and should not be cut off at the knees with such impossibly rigid criteria. Justice is justice. Do not massacre the term with undocumented and highly selective explanations that can only invite allegations of political bias or manipulative pressure from great powers. In the Afghanistan situation, the pretrial chamber overreached without even documenting the basis for its negative determination on interests of justice. It had nothing really to base its assessment on because the proprio motu prosecutor would not have sought authorization to investigate the Afghanistan situation, only to defeat her own application with an assessment that an investigation would not serve the interests of justice. Only the criteria in Article 53(1)A and B are realistically in play when the pretrial chamber judges evaluate the proprio motus prosecutor's application. Your Honors, I want to use a few moments to address some points raised in yesterday's hearing. I think my perspective might be appreciated. First, the impressive representations made by the government of Afghanistan in its brief and yesterday arguing for complementarity missed the point that the International Criminal Court focuses on leadership responsibility for atrocity crimes, while Afghanistan is building a legal system that may indeed bring lower-level individuals to justice someday. But it is implausible for the court to stand down on leadership accountability in Afghanistan, given the ongoing war and political instability and untested resilience of the evolving domestic legal system. The two can run in parallel, with the court focusing on military and political leaders responsible for atrocity crimes, while the Afghan courts undertake the Herculean task of bringing thousands of lower-level personnel to justice. This is how it worked in the Balkans and in Rwanda, for example. Learned Counsel's reference to Article 18 yesterday requires clarification that Article 18, which I had primary responsibility in drafting, only comes into play after an investigation has been initiated, either by pretrial chamber approval of the proprio motus prosecutor's application to initiate an investigation under Article 15, or by the prosecutor commencing an investigation of a referred situation. Article 18 is certainly a procedure Afghanistan can take full advantage of, but first the investigation must begin. Second, Mr. Sekulo's explanation of the American Service Members Protection Act yesterday was incomplete. There has been significant U.S. cooperation in past years with the court because the Dodd Amendment to the Act, namely Section 2015 of the Act, so permits it. But he is correct that when it comes to cooperation with the court with respect to U.S. nationals, the Act does present a formidable barrier. I am more optimistic, however, that one day there will be an administration in Washington that stops being so intimidated by the court, restores the legacy of Nuremberg, along with almost all of its allies, and reasserts America's rightful place as a leader of the rule of law. Third, Mr. Sekulo's reference to the U.S. military justice system as demonstrating that America can take care of its own is a point I repeatedly made in the 1990s in the negotiations when I pressed the complementarity argument. Unfortunately, that point has been soiled recently by the U.S. President's appalling interference with several cases in the American military justice system. I doubt many outside the United States would be impressed with the point anymore, which is unfortunate, as the JAG officers and others whom I have known and worked with through the years in the military, who uphold the highest standards of conduct under international law, are to be respected for their integrity and enforcement of the Uniform Code of Military Justice. And yet leadership flows from the top, and right now it is not a very honorable outcome. I fear it will now take many years to restore the credibility of the argument. Fourth and finally, Mr. Sekulo's very able argument regarding the posture of non-state party nationals under the Vienna Convention in respect of the court's personal jurisdiction is one I know well. I argued it as a negotiator and ambassador in the 1990s, but it was a policy statement that followed the Rome negotiations, one that I introduced before the American Society of International Law as an official position in early 1999. So it really was not an explicit component of original intent in the drafting of the Rome Statute. It also gained little traction either with governments party to the Rome Statute or in academic circles. I find it now a rather retrograde...
Professor Scheffer, you have 2 minutes left.
Okay. I find it now a rather retrograde rationale for bailing out of the quest to end impunity for atrocity crimes. It is an argument that flies in the face of one of the most fundamental rules of criminal law, namely territorial jurisdiction, and defies common sense regarding atrocity crimes, some of which indeed have entered the realm of jus cogens, as Judge Carranza rightly pointed out yesterday. I do believe there was a sloppiness that emerged in the rushed final draft of the Rome Statute on July 17, 1998, that presents an interpretative dilemma for the court on this matter. And I point you to my 2002 article in the Cornell International Law Journal and my 2004 article in the Journal of International Criminal Justice, as well as my book, All the Missing Souls. The basic point is that one of the principles we operated under in the negotiations leading to the Rome Statute is that a state's conduct and that of its nationals for purpose of international criminal justice prior to becoming a party to the Rome Statute would not be reviewable unless Article 12.3 were activated. This would incentivize universality of membership by encouraging states to enter the treaty without fear of ex post facto justice over its nationals and its own conduct. There may be some merit for the court to examine this issue in the Afghanistan situation, including the cluster of treaties referenced by Mr. Sekulow, and settle this legal issue once and for all. The Myanmar, Bangladesh matter and others will increasingly bring the issue of non-state party nationals to the fore in the practice of this court. So, the appeals chamber should reverse the pretrial chamber's decision on interests of justice, and upon review of the pretrial chamber's own evaluation of jurisdiction and admissibility, authorize the investigation of the Afghanistan situation to the extent that the appeals chamber decides that it meets jurisdiction and admissibility requirements. I have a couple of other proposals for the future, but I'm open to those in the questions.